Two matters, Your Honor. One, the first thing that Mr. Steele has requested of the court regarding the representation that the state made about other YSL members contacting Jeffrey Williams for representation is absolutely and has always been a part of what the state expects will show at trial.
I'm going to deny that portion. But to Mr. Steele's point, I'd already made that issue in terms of his particular involvement, and anything you need to let me know prior to that, and I need to rule upon it. And also subject to foundation. And just like this, so I assume that what you told our jurors is what you expect the evidence to show? Yes?
Yes, definitely.
All right, so I'm going to overrule that part of his objection. What about the last thing you mentioned?
And, Your Honor, as to the court's directive that we turn over anything or any exhibits or photographs, that was my understanding of the court's directive, that we expect to show an opening statement. As a matter of course, I can again reiterate the fact that it was an inadvertent omission to leave Mr. Steele, at least part of his name, on here.
I got that, but he's talking about, is there anything else you're going to use in opening you haven't shown to defense counsel? He's telling us, well, I said that. I told you to do that a week ago. Because here's what I told you was going to happen. I've got a jury that's out right now that's being interrupted. And Mr. Williams, you should have made your motion or should have told me about that an hour ago or when you found out about it. Not hijack me at the bench about that. You did what you had to do, but I'm not happy about that. I'm not happy about any of this. Because this is stuff we could take care of before our jury comes in. And that makes you all, lessen your ability as advocates and lessen our ability for this jury to go ahead and get this case seamlessly. This is what I told you all was going to happen. So, have you given them everything you're going to show them during opening statement?
Your Honor, I haven't given them all of the word slides. I did give to them what Mr. Williams objected to. I had given that to them previously. I will give them or share with them the things that have been added as of this evening. And
can you do that over the next 5 minutes?
I sure can.
Deputy Ingram, can you find out if our jurors are ready? Are they ready? Are they still using the restroom?
I will send that to them right now as we're waiting.
Your Honor, we have Your Honor, Jay Apt on behalf of Mr. Kendrick. Can we have 5 or 10 minutes to review whatever Ms. Love is going to send us?
You can take a comfort break, and I'll come back at 10 of 12. And like I said, whatever we don't finish before 12:15, we'll pick up after lunch. Okay?
Thank you, Your Honor.
Who's talking?
That's Sharp.
Yes, Mr. Sharp.
On behalf of Mr. Stillwell. We've been operating pre-trial with the Harvey rule. I want to make sure that the record is clear that we join Mr. Steele in his motion for mistrial. And if Your Honor...
I'll apply the Harvey rule unless you tell me otherwise. Okay?
And that will apply throughout trial?
Yes.
Okay, thank you.
Unless you tell me otherwise. Okay? All right.
Thank you.
All right, we're going to be in recess about 10 minutes, all right?
Your Honor, what I'm going to do before sitting is I'm going to actually do a search.
All right, this was just a bit ago, and so you could feel the tension starting to rise. Kelly, have you ever been in a situation where you're delivering an opening and you get objection after objection, and then the jury actually gets sent out?
You don't ever want to be in that situation because it ruins your flow.
Yeah.
And so then when you have someone that keeps objecting to what you have in your head, you just, in a way, you can lose your place. I mean, you really have to know your opening statement or you're going to get messed up. And you can see here the prosecutor is just really trying to defend some of her actions here, saying that maybe she didn't supply every single detail, but tried to. We're going to have to see what the judge says, but clearly he is not happy.
No, he's not, and it was clear that he had ruled on this recently, like within the last couple weeks, so he remembered that he had ruled in a certain way, and it seems like the prosecutor's definitely backpedaling a bit. All right, let's go back now and pick it up after that little break, and the argument continues. The jury's still not in the courtroom.
Including things, but, Your Honor, that is not an intrinsic act in the sense of it being a crime or a criminal act, and it is what the evidence is going to show happened. What I have in the PowerPoint, I can show to the court if you like. I sent that to defense counsel prior to today. I think I sent it Friday before 5. But what I have said is that on the day that Shamel Drinks was, I'm sorry, Jamari Holmes, my apologies to the court and to the family members here. What I said was that on the date that Mr. Holmes was gunned down, 12 hours after that murder, Mr. Ryan posted on his Instagram account, I bet YSL makes the news. And what I endeavored to say to the jury that the evidence will show is just that they were advertising and representing and boasting on behalf of the gang itself immediately after the murder occurred. And these are elements that the court, I believe, will hear from detectives and evidence. These are the things that the courts have said jurors and the courts should look to in determining whether something is done in furtherance of a gang. And so I would ask the court, I did take it out as the court instructed. I would ask that the court allow me to make reference to it. And thank you, Your Honor, for your time.
All right, Mr. Williams. Oh, sit down, Mr. App. You can just wait a minute. All right, Mr. Williams. What's your response, madam?
That the court already ruled on that, saying that you would bring it up as it comes forth. You stated that they couldn't use it in the opening, and I would just ask that the court use their instruction and make the state follow the instruction that the court already gave.
Okay, but it may not be what I think that Ms. Love is saying, Mr. Williams, is that the evidence may not necessarily be intrinsic. It might be for another purpose, is what they expect the evidence to show. So, but here's the issue that kind of I'm disappointed as the court. You all could, we've had months and months and months. We could have taken this up before. I could have made it very clear. I don't need to take it up right on the eve of our jury sitting in the box. That's what I'm kind of more annoyed with than anything else. If you had clarity or wanted to seek clarity on that, I'm more than happy to rule on it, but I needed to go ahead and have some ability to do so. So I don't think it's intrinsic. It may be for other purposes, and I'll let the state reference that if they have a good faith basis to, that if they believe that's what the evidence will show. Okay?
They put it in their motion as...
Say again, madam? I'm sorry.
They put it in their motion as intrinsic evidence, though. So they shouldn't have put it in their motion if they were going to...
Yes, ma'am. I would probably agree with you. But
So
did I ever rule on that issue?
You said that you would do it later as it came
Okay,
up.
well, here's the thing. Later is now. I got a jury in the box, so you could have asked me that an hour. I mean, we had time this morning. I could have gone through that this morning and made clarity on it for both sides. But do you have any other basis for the ruling? I mean, for my ruling, madam, any other argument?
No, just I wish that the court would just follow their own instruction.
Well, I'll follow my instructions when you all bring to my attention what you need to in a timely manner, okay? And give me the full breadth of, so I can rule upon it accordingly. That's what I'd like you all to do.
Well, they also have slide 45. They have my client's name on there as gunning down a 23-year-old, Shymel Drinks, and my client has nothing to do with that.
Another area.
But I didn't get that
Ms.
slide
Love says
presentation earlier.
Ms. Love says she is going to remedy that and exclude it.
Thank you, Your Honor.
Okay, all right. Now, Mr. App, what is it you want to tell me?
I am so sorry, Your Honor. But thank you for allowing me to speak. I do have an objection, Judge. So, Ms.
What's your objection specifically, sir?
attempted to email us during the break the PowerPoint slides that she is using in opening. I could not open the attachment. I brought that to the attention of her co-counsels and staff, and Mr. Matthews was able to open it, and I looked over his shoulder and was able to see some of it. There are at least a dozen more slides that were never turned over to us, even though the court instructed us to share with the state and for the state to share with us prior to opening any exhibits for opening argument. And so, I mean, these are all new to us, and I would just ask that the ones that she did not share, she shared 4, that the ones that she did not share be excluded. I'm objecting because the court ordered for us to share these. She did not. Clearly, she did it intentionally. There's also apparently factual errors in them. I would ask that any slides that haven't already been shown to the jury and that she did not disclose be excluded from her opening argument.
Yes, ma'am, and then I'll go on to the next person.
Thank you, Judge.
Yes.
Your Honor, I did not send only 4 slides or attachments. I sent to counsel for the defendants the photographs, the evidence that I intended to put into the opening PowerPoint. As far as the state's theory of the case and theme of the case and the words that I wrote, those are things that were being developed, ongoing, and I did not understand the court's directive to me that we needed to turn over the words we would be speaking. As far as these photographs go, Judge, I sent to them if they can. Actually, I sent them to them. So there are some. I have only about.
Your Honor, they're done.
Hold on, wait, let her finish, and then I'll let you respond, Mr. Apps.
So all of these slides that involve Christian Eppinger, I sent to them. And other than the slides involving Christian Eppinger, there is a slide of the vehicle that Donovan Thomas drove on the day he was gunned down. It's the back of the vehicle with the placards of showing the bullet defects. That will be shown. There's no one that has made any objection to that evidence being introduced at trial. Nothing that I have put in the PowerPoint includes anything that has been objected to as being admissible at trial. And I believe that I'm not certain if Mr. App thinks that we only served 4. Maybe, I don't know if he had trouble opening it up, but we served, I think, all of them, if not the great majority of them, because I don't have that many. I don't even have 20 photographs in this PowerPoint. So everything, and I can show the court, I would share it if I did not, with the court as well. But these photographs, I have a picture of Donovan Thomas in life. I have a picture of the barbershop where he was gunned down. I have a picture of the back of Donovan Thomas's Tahoe. I have a picture of Donovan Thomas's headshot. At the time of the autopsy, no cutting, no nothing, just his face with the number. I have a picture of, as I stated earlier, Your Honor, the truck with the defects noted, and then I have pictures of Christian Eppinger, all of which were provided, and that's the extent of it. The majority of the slides have my words, my work product on them.
All right, Mr. App, before I go ahead and respond.
Your Honor, no one's suggesting that she had to turn over the text of her opening argument. But if she's going to show a PowerPoint to the jury, that is what the court instructed us to share. We're visual exhibits, and that's what she's doing. She's placing it up on a screen for the jury to see. And whether that's her own words as part of her opening as a PowerPoint, or it's just demonstrative, she could have shared it, and she didn't. And she did it. And she's suggesting now to the court as a work in progress that she hasn't worked on her opening statement until this past weekend. I don't believe that. I think if that's the case, then she's just lying to the court. But if that's not, if it's not the case, and she didn't mean to mislead the court just now, then she could have and should have shared those PowerPoints. As to the photographs, those also could have been shared with prior to opening. No one's suggesting they're not admissible at trial. If they're admissible, she can admit them at trial. But to show them to the jury now is part of our opening that violates this court's order that we were supposed to share our exhibits for opening prior to trial, which she did not do. So I think they should be excluded from the opening. And if she wants to introduce them later as evidence during the course of the case, then so be it. But I think there is good grounds for this court to, and Your Honor got upset because these issues could have been handled. They didn't have to wait until now. This is wasting time while the jury's waiting. Your Honor's right. And it's not our fault. It's her fault for not doing what the court instructed. And as a result, the appropriate and reasonable remedy is to prevent her from sharing any of these slides with the jury that she did not share with defense counsel prior to today.
What a heated start to this trial.
It's going to be a long one.
It is going to be a long one. Oh, wow. We are going to get in a quick break, and we will get you back for more arguments just in a few minutes. Stay with us. You're watching Court TV Live, your front row seat to justice.
Alec Murdaugh, convicted double murderer, just accepted a plea deal from prosecutors.
How do you plead?
I plead guilty, Your Honor.
He stole the money from Tony Satterfield.
Over $1 million of his own client's settlements.
Why did you agree to that?
Because I trusted him.
This unbelievable fall from grace.
I was selfish, and I just took the money.
The Murdaugh Stolen Million Sentencing. Live coverage Tuesday morning, 8, 7 Central on Court TV.
Welcome back to Court TV Live. The trial for rapper Young Thug is underway in Atlanta today.
The Georgia jury will have to decide whether Young Thug is the kingpin of a violent street gang called Young Slime Life, or YSL.
The defense claims Young Thug has no association with any street gangs and that YSL is just his record label name.
Now, all morning long, it started with the state's opening statement, but after about 30 minutes and a few objections, the judge had to actually let the jury out of the room, and now it has been about an hour since the jury was in the courtroom. They've been going back and forth, arguing about some demonstrative items that the state put up on the screen. The defense had not seen. The ruling was everyone was going to share, and here we are. Let's bring in criminal defense attorney Elizabeth Baker. She's been watching all morning in Eugene. Now, what are your thoughts, Elizabeth?
Well, I'd say, the L word has been thrown around the courtroom already, which is pretty interesting, just straight out accusing the prosecution of lying about, having this be a good faith error. I think the judge is just getting more irritated is what is going on. And it is not good trial management. And this is because the prosecution failed to share these things. When the judge remembers the ruling, it is not a good sign for the prosecution.
No, Elizabeth and Ted had asked me if I can recall a time during opening statements where somebody was objected, and I had to go all the way back to my first practice in law school where another student got up, kept objecting, and I was getting frustrated. But then you learn. You want to take measures to make sure that doesn't happen again because it can really throw you off. Here, in this situation, we had the prosecutor that clearly, according to the allegation here, did not follow the judge's order. And so in a way, it's throwing her off. Now we're in this situation where this is being delayed even longer. Can you kind of just speak to that and what this means for her case going forward?
Well, I think at a minimum, it means that that the defense is going to be watching her very, very closely. You can see their frustration, the way they're voicing their objection to the court. The court is growing more frustrated because it really is a management problem at this point. And the judge's focus is on jury comfort. The jury's back there. They're already starting to think about stuff that the judge doesn't want them to think about for quite some time. It just doesn't bode well for the flow of this trial at all. I think the defense objections are well taken. They're not being superfluous. They're not, I think they're stating it very clearly. It's a problem. She sends the exhibit to them. They can't open it. Whoops, judge, sorry, I had no idea. That's just not a thing.
Yeah, I mean, the fact that the judge did rule that they have to share, that seems pretty evident by the back and forth there. And then there are more slides than what was shared originally, and then fine, I'll share them, and you can't. It is turning into a nightmare. And it started with a missing juror this morning, so maybe that was the beginning of what is going to be a clunky, at least first day. Let's go back in. We're going to pick it up again. The jury's still not in the courtroom, arguing, attorneys, and the judge in the middle.
Whether they're evidence or whether their text is part of our opening.
All right, Mr. Matthews.
Yes, Your Honor. Good morning to the Honorable Court. I'd like to direct the state's attention to slide 15. In slide 15, the third bullet point, it references October 1st, 2020 in terms of that quote from the text message. In the indictment, Your Honor, if you look at Overt Act 102, that's where that particular quote comes from, Overt Act 102. In Overt Act 102, the date of that alleged text message was March 12th, 2020, not October 1st, 2020, as in the PowerPoint presentation. That's number one. Number two, the quote in the indictment is different from the quote in the PowerPoint. So that's two errors in slide 15 pertaining to Marquavius Huey. And then when you go to slide 16, slide 16 is an overt act that is alleged in the indictment as Overt Act 123. In the state's opening presentation, the date they have is October 1, 2020, but in the indictment, that particular overt act is November 16, 2020. So that's a third error in the state's opening slide presentation. So those need to be corrected to mirror the indictment so that it's not misleading the jury and in fact giving wrong information to the jury, Judge. So I'll ask that the state correct that, remove it, or correct it.
All right. Anybody else? Yes, Mr. Short.
Your Honor, on behalf of Mr. Stillwell.
Speak up, please.
On behalf of Mr. Stillwell, slide number 47, it suggests that Mr. Stillwell is still committing crimes on behalf of the gang even after being indicted on these charges. We began to discuss intrinsic acts and other unindicted allegations last week, but we did not get through it. And my understanding was that anything that you had not ruled upon, we were not supposed to reference or discuss in opening statements. So those are clear references to unindicted charges that we did not get a ruling on its admissibility yet, and I would ask that that just be taken out of the presentation and no mention be made of those.
Anybody else? Yes, Mr. Steele.
Thank you, sir. If you would look at also number, I'm looking at it now, 48, 49, 53, 54, 55. That's your prerogative. That's within your zone. That's law.
Would the court allow Mr. Steele to repeat those slide numbers? Because what I think that he's referring to is something that I placed in here that the court said during its preliminary instructions to the jury. And it was regarding the court, as a matter of fact, it was the last thing that the court said. And all that I did was put on the slide, Judge's law.
In terms of what slides you talking about, Mr. Steele, again?
I have 48, 49, 53, 54, 55.
So 49, 48 through 55?
Excluding, so 48, 49, but then skipping to 53, 54, and 55.
48 and 49. Your Honor, may I share via Zoom the slides that Mr. Steele?
I would, yes, please, ma'am.
Thank you. And you said, Mr. Steele, you said 45?
Just share the presentation, please.
Yes, Your Honor.
All right, the arguing continues outside the presence of the jury. A clunky start to the beginning of this case. We'll get a break in here, get you back to the courtroom for more right after this. Welcome back to Court TV Live, along with Kelly Craft and Ted Rowlands. It's been a very interesting morning and now early afternoon.
Yes, Ted, we are bringing you the young thug RICO trial that's happening out of Atlanta, Georgia. The jury has been dismissed as the two parties discuss issues with the state's opening statement.
Yeah, and Young Thug, whose real name is Jeffrey Williams, 5 other defendants also there. They're all facing gang and racketeering charges. Prosecutors say this group is behind a number of gang-related crimes spanning the course of a decade. Let's go back, pick it up again. No jury, just attorneys and a judge.
Your Honor, I'm showing on the screen slide 48, which is the last statement of the court.
Take notes.
Yes, Your Honor.
All right.
And
49.
that was directly from what the court just stated.
All right. 50.
50.
It's not 50, sir. 53.
53. Okay. Let's get down to 53. And 53 is what I expect the evidence is going to show. So I'm going to, in speaking to the jurors regarding the witnesses and the instructions that the court has given them, I'm going to say to them, some of them, as I've already alluded to, some of them may not be wanting to speak. Some of them, you're going to see evidence that some of them are afraid. Some of them are embarrassed. Some of them are intimidated. Some of them don't remember. Some of them don't want to remember. That's simply what the evidence will show. And, Your Honor, what I'm asking that the jury does in listening to and considering the testimony of any such witnesses is, as the court has already instructed, which is just to use your common sense because you alone decide who you believe. We're asking you to listen carefully, take notes, and pay attention. So there's nothing in that slide 53 that is in any way infringing on or entering into a lane that does not belong to the state. We are entitled and allowed to show and to state to the jury what the evidence will show. The way that I have decided to represent it in writing makes it no less so.
Yeah, but it borders on argument at this point in time.
So I can change it because I do expect that the evidence will show that some of the witnesses are afraid. Some of the witnesses are embarrassed. So I can take out.
Well, that's different. You might want to just redo it.
I can do that.
Any further objections, folks?
Yes, Your Honor. I went over to the state's table, Carson Matthews and Beth Julia went over to the state's table and brought to their attention an error in slide 42, and I think it's incorrect.
All right.
Is that correct, State?
All right, here's what I'm going to do. Folks, this is exactly why I told you I wanted you to, and let me go ahead and just say this, Ms. Love, I told you to give them your PowerPoint presentation. This is why you give it to them, so that they can get errors and they can also figure out if there's something they object to. So this is what's caused this delay. Because at this point, like I told you, there's no secrets in the trial of this case. You all have gone through quite a long process. But this just highlights the concerns the court had in terms of just breaking up the presentation for our jurors. So what I'm going to do, ladies and gentlemen, I'm going to go ahead and call our jurors out. I'm going to go ahead and release them for lunch. I'm going to tell them they're going to be at lunch until 1:30. During the lunch hour, Ms. Love, I want you to play for the slides that you have that otherwise have not been shown. You need to show them to the defense counsel and make sure they're correct. In the absence of them being corrected, I'm going to exclude your presentation.
They have the presentation.
But it needs to be correct. I don't want, if I get another objection about an error, I'm going to exclude it for the purposes of the opening statement because you didn't follow my instructions. This is why I told everyone. And the defendants needed to give you their opening statements and the things they wish to use during their openings as well, because we're having interruptions and delay, and that's what I wanted to avoid for our jurors. That was the reason I told you all to do that. So,
Your Honor, as far as any typographical errors,
I'm not worried about that. I'm not worried about that. But I'm not worried about that. But the errors that Mr. Apt, Mr. Matthews, and Mr. Shaw have made are errors, and Ms. D. Williams need to be corrected. Okay?
yes, Your Honor, I will, of course, do it for the record.
And but everyone else needs to see it so they can be comfortable and make sure that you've represented something that what you expect the evidence to show to be correct. Okay?
Thank you, Judge. Will do. And Your Honor, I also wanted to point out to the court that even if I misspoke, the court has already instructed the jury and will continue to instruct them that nothing I say is evidence, and if I misspeak or miswrite,
but that's not the point. I'm going to tell them that. But and I've told them that already. But that's not the point. The point is so that we can have a smooth and orderly presentation of evidence. Okay? So, all right. Sergeant Ingram, can we go ahead and call for our jurors, please?